Hello, my name is Justin Storch. I am SHRM's Global Content Strategist. I'm here today with Tracy Schauff, who is a senior attorney with Fakhoury Global Immigration, and we're going to talk today about an issue that's arisen at the Canadian border with L1 visas. L1 visas are intra-company transferee visas, and historically you've been able to process extensions at the Canadian border, but that's changed a little bit, and that's what we're going to talk about today. Tracy, can you explain what U.S. Custom and Border Protection's policy at the Canadian border is for L1s and what it used to be and how that's now changed?
Sure. CBP has always been a place where we could go and get L1 petitions, whether they be an initial L1 or an extension adjudicated, which was great because it's a one-step process, really. Rather than filing with USCIS, you would send your client to the border with the L1 petition, and it would be adjudicated on site with no premium processing fee, and you would be able to get your answer right away. And then the adjudicated petition then gets sent to USCIS, who would issue the I-797 later. So we've been doing that for years, sending them to the border. To most of the POEs would accept the cases or the pre-clearances at the airports, such as Toronto or Vancouver. And now they have changed their policy. It started slowly. We saw it at a couple different locations. Toronto Airport, the Pearson pre-clearance was one of the first to start denying the acceptance of L1 extension petitions. So the policy has changed only in regard to extension L1s. Initial L1s can still be processed at any POE who's willing to do them. But unfortunately, we now must send L1 extension petitions to USCIS. So we first started seeing this out of Toronto, I think. And what it was they were saying we are no longer going to adjudicate these. And it slowly spread throughout the POE. And we have now learned, and CBP has come out and made a statement about it saying that they will no longer allow for extension filings to be completed at the POE. They must all be sent to USCIS. Though I will say this policy does not apply to anyone who's an L commuter because they don't face the same types of time limits as somebody who would be on a normal full-time L1 within the United States.
Thanks, Tracy. So, what are the practical implications for employers now that they do need to file these extensions at USCIS?
Well, one of the biggest practical implications is the delay in processing, and another is the cost. So most people will try and file premium processing just because of the expediency, but at the border we didn't have to pay that fee, and it was still adjudicated in a day. Here, filing with USCIS, most of the normal processing times are longer, and it just takes more preparation. The documentation that USCIS has been requiring has tended to be more substantial than we see at the border. They're also less likely to request a large amount of additional information, which we're typically seeing substantial RFEs on these cases. And the border may come to you and say, hey, we need one more thing, or there's a question about one piece of it. But we generally didn't get those types of long RFEs that we would see from USCIS. Just the inconvenience of it, too, instead of being able to say, hey, you're going to be back in Canada, you can just stop and pick up your new or extend your L1 on your way back in. We no longer can do that. Now you have to plan ahead, and you must make sure that you have time to have the L1 adjudicated in time for travel if necessary. So there's some other strategic decisions that have to be made that maybe we didn't have to make previously.
So, what's your general advice for preparing the filings that you're filing at USCIS? I know you already mentioned premium processing, but are there things that employers should be considering to make sure that their petition is approvable?
I think that they have to understand that how USCIS looks at a petition and how the border has typically looked at a petition are somewhat different. I've always found that CBP likes a more concise application. While they want to make sure that all the information is contained within the petition, they don't seem to need as much in-depth documentation as they do usually at USCIS. So employers should be prepared to provide additional information that they may not have necessarily included with a petition that was filed at the port of entry. For instance, you go to the port of entry, they're more likely in the past to look at the fact that there was a previous L1 approved and use that as part of their case analysis, saying is really just still an extension of what they've been doing before. It was previously approved. And USCIS, we've seen in a number of case types, has moved away from that, giving deference to prior petitions. And so looking at a filing with USCIS, I would file it almost as if it was always a new one, because USCIS tends to put a little more scrutiny into them. I don't want to make it sound like CBP was easy on these, or that you could get something through CBP that wouldn't necessarily get approved by USCIS. I just think that the way in which you present evidence to CBP tended to be a little bit more concise than maybe what we would normally provide to USCIS. So employers should be prepared to provide additional documentation and definitely more specific details regarding the position than they may have done previously with CBP.
So Tracy, let's go back to the question of processing time. You had mentioned that processing time is something that you really have to consider when you're talking about USCIS. With regular processing, how long is a typical L1 taking right now?
Yeah, it's running longer than it should. I know that the USCIS website's listing 2 weeks to 4 months, but in reality, we're seeing generally about a 3 to 5 month processing time on an L1s filed under regular processing, which
Right.
is better than what we're seeing in some other cases, but still not really expedient.
And then there's always the chance you're going to get that RFE that can really add additional time. If you get an RFE, how long is that going to add?
Well, normally you have 87 days to respond, and the RFEs have tended to be fairly substantial, so just compiling it, if you take the full time, then you're looking at, again, about I would say normally a 45 to 60-day response after replying to an RFE.
Right. So given all that, do you recommend that employers just budget for premium processing and use it as standard procedure?
I would like to say yes, because really that's at least the only way you can get a response done quickly. However, we are seeing a lot of RFEs that tend to be issued on the 14th day. And it's hard to determine sometimes whether or not it's a valid RFE or if it's an RFE to stop the clock. And I hate to have a case that I think is legitimate that maybe is going to get an RFE just to make sure that they get within their 15-day processing time. However, if you are going to get an RFE, even under that scenario, at least they're generally better about responding, once you respond to the RFE, providing you your approval or denial within a reasonable amount of time. So all in all, it is going to allow for better processing times, but you're still not going to see a processing time that's going to be anywhere comparable to what you would get by applying at CBP at the border.
So Tracy, USCIS has also announced that they're extending a pilot program allowing Canadians to request remote adjudication of Form I-129. That's the form that's used for standard L1 filings, as well as Form I-129S, which is the form that's used for blanket L filings by USCIS prior to their arriving or when they arrive at the Blaine, Washington port of entry. Do you see any value in this pilot program?
I do, if its expansion can help alleviate the burden that we're going to see with the restrictions on filing L1 extensions at the border. The whole goal of this program was to alleviate the burden of adjudications from CBP so that they could make better decisions on admissibility. And it's supposed to streamline the process and reduce the burden for employers and do it more timely. So just to go over the program a little bit, the pilot program requires that the petitioner still mail a petition to USCIS. The only difference at that point is the addition of a cover letter that denotes that it is to be part of the Blaine pilot program, which cannot be found online if you're looking for it. But you mail the petition to USCIS. USCIS issues a receipt notice that's provided to the petitioner, and their goal is to do a 1 to 3 day adjudication. USCIS has established a separate group of specially trained individuals who will handle these cases. So the goal is to keep the work within that group so that they can process these quickly. The notification of the approval or an RFE, they can still do a request for evidence, is sent to the petitioner, and then the petitioner can provide that approval to the employee who would present themselves at the border for admission. And then it's just CBP's job to determine if they're admissible. CBP cannot re-adjudicate the petition, but is certainly allowed to ask questions regarding the job or any other details of the position. The other thing is that the employee does not necessarily have to wait for the adjudication. Once it's received at USCIS, they can present themselves at the border and they can request that it be adjudicated, and they will make the adjudication as quickly as possible. Could mean that there would be a wait. The wait would depend on terms of the application, the time involved by the adjudicators, but it could still maybe be done in a day. So this program could be helpful if it's expanded into other locations to allow people who are facing these delays, who are going to face delays because of the new L1A or L1B extension policy that they have to be filed at USCIS. If they can handle a larger volume and get these cases approved quickly, that will at least shorten the period of time for only a few days. And there is, just to note, there is no premium processing fee on this, so that is adjudicated in this shorter time period without an additional $1,410.
So Tracy, it's been suggested by some people that you might want to consider applying for an L1 visa at the consulate instead, given these developments. But is that actually something people can do? Is that something that makes any sense?
It's funny because people have been trying to do that. I have heard a number of attorneys who are advising their clients to utilize the consulate, even though Canadians don't require a visa to come in on an L1. They're visa exempt. And I know Ayla, I think, had brought this up with the Department of State and the consulates, who said that they would review the issue. But my understanding is that those who have tried to apply for visas at the consulate have been turned away. The consulate has said that they do not have the authority to adjudicate this application or petition for those who are visa exempt.
Well, thank you, Tracy. I really appreciate it. I really appreciate your time today. So if you're looking for more resources on immigration and visas, you can look at SHRM's website, shrm.org/immigration. Will take you directly to our immigration resource page. You can find this interview and other interviews will be housed on that page, as well as various other resources. Tracy, I really thank you for your time today.
Thank you, Justin.